everyone. Okay, then we'll start. My first today and last in this during the summer school. The rule of law, a challenging concept for courts, whether it is a challenging concept or not. According to Viviane Reding, the Vice President of the Commission, the rule of law means a system where laws are applied and enforced, but also the spirit of the law and fundamental rights, which are the ultimate foundation of all laws. A system in which no one, no government, no public official, no dominant company is above the law. Equality before the law, fairness and due process. We just talked today, the lecture with Andreas. Guarantees that laws cannot be abused for alien purposes or retrospectively changed. The justice is upheld by an independent judiciary acting impartially and ultimately a system where justice is not only done, but it is seen to be done so that the system can be trusted by all citizens to deliver justice. It is one of the definitions, what the rule of law is, what we mean by how we understand the rule of law. And there are many definitions. There are many definitions, but there is no legal definition, and it is an issue. It is a point. As far as European Union law is concerned, European Union regulations, treaties, provisions, primary and secondary law, there is no definition, and it is the task of bodies, agencies, institutions to develop the meaning, the substance, the content. What the rule of law means. Rule of law. Some general remarks. The concept of the rule of law is political, but first of all, it is legal. It is a political. Because it is enshrined in constitutions as well. That's why it is political, but at the same time it is in legal text. It is a political concept. It lacks a general definition. Hence, the European institutions fill it with content. What I just said. European institutions, mainly it will be Court of Justice, and we look at the Court of Justice, the way the Court of Justice perceives a rule of law, how the court feels. The concept of rule of law with a concrete content. Then European Commission. Yesterday we looked at the framework, EU framework. It was the Commission communique of 214 and the EU framework on rule of law, where Commission gave us a definition what the rule of law means, as well the resolution of the European Parliament of 2013, where the Parliament as well said or just spoke out its view. What the rule of law is. But there are other institutions and other EU bodies, agencies. That as well speak out their view on their understanding of the rule of law, like Social and Economic Committee of the Regions, Human Rights Agency. The rule of law is also important for them. Rule of law is derived from the constitutional traditions of the member states. It is understandable because there is no EU rule of law as such, and very often Court of Justice, when wants to develop, interpret a principle that is not expressis verbis given in the provisions, that is not written in the provisions of the treaties of the primary law. It is not in secondary law, sometimes it can be, but in the primary law, then has to develop this principle, and very often resorts to the constitutional traditions of the member states and resorts to general principles of law. And as far as rule of law is concerned, it is a concept which was developed and which is present in the national constitutions. That's why rule of law is derived from constitutional traditions of the member states and the general principles of law. Therefore, some member states either question the existence of the EU rule of law, and if not, then they give it their own meaning according to national standards. And it is an issue, what the rule of law is. And in different countries, different constitutional constellation, rule of law is understood differently, and we can see it and we can feel it as well when we look at the language. In the English language, we have rule of law, but in the German language, we have Rechtsstaat, and in the French language, we have état de droit. And now it is the question whether a rule of law means the same, equals Rechtsstaat and état de droit. État de droit is close to Rechtsstaat, but rule of law, it seems to be something different. And now, because we talked yesterday about Polish perspective. In the Polish language, we use interchangeably such concepts as praworządność, rządy prawa. Praworządność, rządy prawa, it is close to the rule of law. And on the other hand, państwo prawa, państwo prawne, it is close to Rechtsstaat, to état de droit. And the understanding is slightly different. When we speak about państwo prawa, it means état de droit or Rechtsstaat, or when we speak about rule of law sensu stricte as such. When I am here, it means that they put emphasis on different elements. Praworządność means that the state is ruled by law. Law is above the state. It is guidance. It is a directive of actions both for authorities and society. Whereas państwo prawa, Rechtsstaat, is a concept of a state in which law is supreme, binds rulers and determines the scope of their competences, and guarantees the citizens a number of rights and freedoms. Moreover, state bodies and institutions may only operate within the limits specified by law. One of the elements characteristic of państwo prawa is an independent judiciary and independent judges. It means that the elements when we talked about yesterday, independence of judiciary, independence of judges, independence of courts, it falls under the concept of państwo prawa, état de droit, Rechtsstaat, rather than rule of law. Okay, it is one concept because under the treaties, when you take English language, you have rule of law. But when you take, the same provisions in German language, you have Rechtsstaat, and in French language, you have état de droit. They are equal. It is about rule of law, but one has to be conscious about the slight differences which can be according to the context from which they were taken, because rule of law as such is derived from the constitutional traditions of the member states, and état de droit from the French tradition, and Rechtsstaat from German tradition, and rule of law from UK tradition, or here common law tradition. I don't know whether this what I am speaking about now would be not useless, because as we know, United Kingdom is not a member of the European Union since the end of January 2020, and I don't know if you are aware of the fact that English language is not anymore an official language of the European Union. And I was just surprised because I was looking for a document issued in 2020, and I thought institutions will proceed with English language. They do, but the one important document I was looking at, it wasn't. I couldn't find English language. Because, some people think, okay, we will survive because of Ireland, but Ireland declared Gaelic. It means not English. Okay, then we'll survive because of Malta, but Malta declared Maltese. That's why it is not English. Maybe because of Cyprus, but Cyprus declared its own language. It's Greek. Yes. That's why. Yeah. Then speaking about the rule of law, the rule of law is rule of law. It is in English language. Then and it has its own meaning. Whether it will be not useless in a year. Yes, because English language is not anymore official language. Yes, it is still working language, but how long we'll just see. The founding treaties, Treaty of Paris 1951, that led to the establishment of the European Coal and Steel Community, and then two treaties of 1957 that led to the establishment of the European Atomic Energy Community and European economic community did not contain the concept of the rule of law. And that's why the task of introducing this principle into the European Union legal order fell to the Court of Justice of the European Union. And yesterday I spoke a little about the judicial activism. Court of Justice interprets some issues, some principles, derives some principles via, having its competences, but this what Court of Justice does, we call judicial activism. It stretches the provisions, the understanding of the provisions of primary law, secondary law, of principles of law, with the aim to interpret, to derive the principle that needs for its own purposes. And it was for the European Court of Justice that confirmed and developed the definition, the meaning, the understanding of the rule of law as a general principle of law. It was the work done by the Court of Justice, which was then introduced into the Constitutional Treaty. This concept of the rule of law was introduced in the first part of the Constitutional Treaty. Constitutional Treaty consisted of three parts. It was just at the very beginning, Article 2, but as we know, Constitutional Treaty did not enter into force. It was signed in Rome at the end of October 2004, but it did not enter into force. But what is important, in the Constitution, rule of law was seen as a value, not as a principle, but it was seen as a value. Rule of law as a principle was introduced into the Maastricht Treaty, it was introduced as a principle and as a goal. The Maastricht Treaty referred in its preamble to the rule of law as a principle, but when the provisions dealt with external policies of the community at that time, or common foreign and security policy, referred to rule of law but as a goal. It was what I told you yesterday, that because European Union is not a state, that's why the instrument via which can hold entities, states into account it is law. And in this internal content, European Union deals in this internal context, internal policies, and here rule of law applies, but as well as active in external relations. European Union towards external work, towards international organizations, towards third states. And here as well the principles, we can say that exports principles. European Union behaves as a normative power, as via agreements with external entities, imposes its values, its principles on those entities. Take, for example, association agreements. A country that wants to be a member of the European Union has to comply with the requirements the European Union imposes. And these requirements are written, in these treaties, and countries must comply with them. That's why European Union is called a normative power, imposing its positive principles on other third entities. But what is here important, that the rule of law can be seen as a value, as it was in the Constitutional Treaty. Rule of law can be seen as a goal, as it was in the Maastricht Treaty, in the Treaty on the European Community. Because Maastricht Treaty, it is a general concept, but under Maastricht Treaty, we understand Treaty on the European Union and Treaty on the European Community, on the European Atomic Community, and European at that time still Coal and Steel Community. And it was understood as a principle, and it was understood as well as a goal. Then we had Treaty of Amsterdam that contained a catalogue of principles on which the European Union was based. And in Article F, it is an old article, but it is the Maastricht Treaty. It was Since Amsterdam, we do not have letters, we have numbers, and Article F became Article 6. Article 6 of the Treaty of the European Union, and here we have and here Article 6.1 said that the Union is founded on the principles of liberty, democracy, respect for human rights and fundamental freedoms, and the rule of law, principles which are common to the member states. It means it speaks about principles. But what is here important? Important is that it was Article 6. It was not Article 2, as it was in the Constitutional Treaty. It is important which article it is. The lower number of the article, the higher importance of the principles which are enshrined in this article, in this context. It means that rule of law was important, but one can say, okay, not as important as it is now, because now, under the Lisbon Treaty, the rule of law is enshrined in Article 2. The lower number of the article, the higher importance, the higher value for this principle. The principle of the rule of law has become a treaty principle derived from the legal orders of the member states. It became treaty principles, but it is derived from the legal order of the member states. Its importance increased gradually in terms of both European Union internal policies and external actions. Internal policies and external actions. It is Article 130U, external development policy, and J1, Treaty on the European Union. It is common security and defense policy. It has evolved and continues to place particular emphasis on the judicial protection within the European Union. Rule of law consists of many elements, but judicial protection, independence of courts, independence of judges, independence of judiciary, these are the main elements, the most important elements, the essence of the rule of law. This is what constitutes rule of law. Okay, we can speak as well about separation of powers. It is another element which is one of many that constitutes rule of law, but it is not the essence. Of this concept. Under the Lisbon Treaty, this treaty contains a catalogue of values on which the European Union is based. I just referred to Article 2, Treaty on the European Union, and it is important because it is Article 2 and it is not Article 6. The Union is founded on the values, not principles, not goals, but values. On the values, and one of them is rule of law. A Treaty on the European Union includes the term borrowed from the constitutional law of the member states. Rule of law, and thus abandoning the more adequate, less controversial concept used by the court, community of law. Yeah, that is the point. We speak about the rule of law. We borrow this concept from the constitutional traditions of the member states. We borrow this language from constitutions, from national constitutions, from constitutions of the member states. But there is a concept in the case law of the Court of Justice of the European Union, and now of the European Union, at that time Court of Justice, European Court of Justice, or Court of Justice, but referral is to the community of law, and it seems to be more adequate, to be more appropriate concept, because European Union, it is an organization, it is a community, yes, it is economic community, but it is as well, it is economic community, it is political community, but it is, in the first place, it is a community of law, and this term, community of law, seems to be more adequate for this entity, which we call European Union. But when we speak, when we say rule of law, and we borrow it from the language, we borrow the language from the constitutional traditions of the member states, then it imposes, okay, then what the European Union is it a state-like entity? Is it a constitutional structure? We'll see then very often when Court of Justice referred to the rule of law, at the same time Court of Justice referred to the Constitutional Charter of the European Union, treated or perceived the treaties, the founding treaties, as constitutions when spoke about the rule of law. Then a catalogue of values was placed at the beginning of the treaty of the European Union, thus showing the importance the authors attached to the axiology, what I just told you. I mean, the lower the number, I mean, the higher the importance, the bigger the importance of the value of the principle. A systemic interpretation leads to the conclusion that the entire treaty regulation is based on values the European Union should take into account in all its activities. It means that it is based on values. Values, we have goals, we have principles, we have values, but values are the most fundamental. These are the fundamentals. And when they are at the very beginning of the text, of the legal text, it means, it implies that it is valid for the whole text. Not only for some provisions, but I mean these principles which are enshrined in the very first provisions of the legal text, they are valid for the whole text. But here, when we speak about values, these are the basic principles, the most fundamental principles, using the language. Goal is narrower, principle is narrower, but I mean, value, it is the most broad category that is possible. While the Treaty of Amsterdam refers to principles, the Treaty of Lisbon refers to values. And this change has its consequences. It is not without consequences. Charter of Fundamental Rights refers to principles of democracy and the rule of law on which the Union is founded, as opposed to the values of human dignity, freedom, equality, and solidarity. Still, in the Charter of Fundamental Rights, we speak about principles. Yes, but you know, Charter, it was December 2000, and the document, which at that time was not even binding because it was a declaration, which was attached to the treaty, and now it is binding. It has the same value as the provisions of the treaties. But at that time we spoke rather about rule of law as a principle rather than as a value. And the preamble to the Charter says that the Union is founded on the indivisible universal values of humanity, dignity, freedom, equality, and solidarity. It is based on the principles of democracy and rule of law. Once more, we see here the principles. It is a rule of law is a principle. Article 47 says everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal previously established by law. Values are the basis of the axiological order of the European Union, what I just mentioned, from which the principles are derived. The rule of law is a value and a general principle of EU law at the same time, a value and a general principle of EU law. As a value, the rule of law is structural constitutional principle because I mean it is the basis. It is as I said the most fundamental principle. The primary axiological norm, which is superior and justifies deriving from it the principle of the rule of law as a general principle of law. As a principle, it has two aspects, and it is formal and substantive or material. Formal, in other words, procedural, and substantive. We speak here about liberties, or we understand here liberties and rights. European Union institutions referring to the Code of Justice, referring to the rule of law. As I said at the very beginning, many institutions referred to, especially European Commission, Committee of the Regions. But Committee of the Regions is not an institution. Committee, Economic and Social Committee, Fundamental Rights Agency, but the European Parliament, what I just referred to. But for us, the most important is Court of Justice of the European Union. I mean the view, I mean the understanding of rule of law by the Court of Justice of the European Union. And the first judgment in which Court of Justice referred to the rule of law, it was a judgment. It was so-called Lever from 1986, and the court said it must be first emphasized in this regard that the European Economic Community is a community based on the rule of law, inasmuch as neither its member states nor its institutions can about a review of the question whether the measures adopted by them are in conformity with the basic constitutional charter, the treaty. And it is important what I said. Rule of law is very often in a line with this constitutional appeal or this constitutional language that it's constitutional. Basic constitutional charter, the treaty. Because rule of law is enshrined in national constitutions, rule of law enshrined in the primary law is seen as a part of this constitutional structure. And then it was in opinion 191, the court said, in contrast to EEC treaty, albeit concluded in the form of an international agreement, nonetheless constitutes the constitutional charter. It is an international agreement, and there is no doubt about it. And European Union, it is an international organization, there is no doubt about it. But at the same time, it's perceived as a constitutional charter of a community based on the rule of law. Okay, I will not read the whole paragraph, but I go further. The Court of Justice of the European Union, referring to the community of law, or community based on the rule of law, using the word community, that seems to be more appropriate, adequate for this structure that is not a state structure. In the judgment of 2002, the court said the European community is, however, a community based on the rule of law, in which its institutions are subject to judicial review of the compatibility of their acts with the treaty and with the general principles of law, which include fundamental rights. And then, as far as community of law goes, because first I referred to the rule of law, État de droit and Rechtsstaat, and now we see the same, in different languages, community based on the rule of law in English language. Then we have Communauté économique européenne, Communauté de droit, and die Europäische Wirtschaftsgemeinschaft eine Rechtsgemeinschaft ist. In the community of law, in the English language, we have a community based on the rule of law. It is based on the rule of law. But we have a very clear in the German language, eine Rechtsgemeinschaft. Yes, it is a community of law. It is a community of law. Eine Rechtsgemeinschaft is Communauté de droit. It is the same. It is the same here in French language. But it is this referral to the community, to the more adequate word, or just word. Then to speak about rule of law as such, only about rule of law. And this term Rechtsgemeinschaft, it was introduced for the first time by Walter Hallstein, the president of the European Commission. In other judgments, the court also said the European Union is a community based on the rule of law, inasmuch as neither its member states nor its institutions can avoid a review of the question whether the measures adopted by them are in conformity with the basic constitutional charter. Community based on the rule of law, but here, yes, we have a referral to the constitutional charter, but it is a judgment from 2014. In Lever, it was in 1986, and at that time, it was a referral to the constitutional charter. The European community is a community based on the rule of law, in which its institutions are subject to judicial review of compatibility of their acts with the treaty and with the general principles of law, which include fundamental rights. Individuals are therefore entitled to effective judicial protection. Community based on the rule of law, individuals are entitled to effective judicial protection. We talked about it yesterday. It is Article 19 on the European Union of the rights they derive from the community legal order, and the rights to such protection is one of the general principles of law stemming from the constitutional traditions common to the member states. Community based on the rule of law, effective judicial protection, general principles of law, and constitutional traditions common to the member states. Then the Court of Justice refers to the rule of law as a value. And in the judgment of March 2017, it is said that as is apparent from Article 2 of the Treaty on the European Union, which is included in the common provisions of the EU Treaty, and Article 21 of the Treaty on the European Union concerning the European Union's external action, to which Article 23 relating to common foreign security policy refers, one of the European Union's fundamental values is the rule of law. and then reiterates its position in another judgment. In that regard, it must be noted that, as is apparent from both Article 2, which is included in the common provisions of the EU Treaty, and Article 21, concerning the European Union's external action, to which Article 23 relating to the common foreign and security policy refers, the European Union is founded in particular on the values of the equality and the rule of law. In this connection, the court's settled case law should be recalled, according to which European Union is a union based on the rule of law, now union based of the rule of law, in which all acts of its institutions are subject to review of their compatibility with in particular the treaty's general principles of law and fundamental rights. And here we have founding values. One of the founding values is the rule of law. La valeur de l'état de droit, I mean the value of l'état de droit, and Wert des Rechtsstaats, I mean in the German language. As I told you at the very beginning, there is no difference. We speak about rule of law, but each language has its own meaning, and especially as far as rule of law is concerned, because it is derived from the constitutional traditions of the member states. Then we have to be conscious of this. That can be differences, national differences in the understanding what the rule of law means. Court of Justice referring to the independent courts and effective judicial review. In one of its judgments said that it may be added that Article 47 of the Charter, which constitutes a reaffirmation of the principle of effective judicial protection, requires in its first paragraph that any person whose rights and freedoms guaranteed by the European Union law are violated should have the right to an effective remedy before a tribunal in compliance with the conditions laid down in that article. It must be recalled that the very existence of effective judicial review, existence of effective judicial review designed to ensure compliance with provisions of European Union law is of the essence of the rule of law. The essence of the rule of law is the existence of effective judicial review. And then the very existence of the effective judicial review designed to ensure compliance with the provisions of EU law is inherent in the existence of European Union law. Judicial review that Andreas just talked today about is one of the main elements. Constitutes essence of the rule of law, and that's why it is so important. In other judgments, as you can see, refers as well to the Court of Justice says as well the very existence of effective judicial review designed to ensure compliance with provisions of European Union law is inherent in the existence of the rule of law. Then the confirmation of the principle of effective judicial protection in Article 47 of the Charter of Fundamental Rights. Everyone whose rights and freedoms guaranteed by the law of the Union are violated has the right to an effective remedy before the tribunal. The independence of courts and judiciary should be as well seen in the context of the principle of separation of powers, which serves to uphold the rule of law. It is something what helps upholding rule of law. For according to this principle, the judiciary should be distinguished from executive. And in the judgment of the Court of Justice of 2016, we can read, in the first place, it is generally accepted that the term judiciary does not cover the ministers of member states. The term refers to the judiciary, which must, as the Advocate General observed, be distinguished in accordance with the principle of the separation of powers, which characterizes the operation of the rule of law. The principle of separation of powers, which characterizes the operation of the rules of law. It means helps upholding the concept, the principle, the value of the rule of law from the executive. Thus, judicial authorities are traditionally construed as the authorities that administer justice, unlike inter alia ministers or other government organs which are within the province of the executive. And then for the development of the rule of law in the European Union in terms of judicial independence, it is the issue that we hear, just is I mean, the main issue of our discussion today and yesterday, in terms of judicial independence, the landmark judgments come from 2018, and it is a judgment that we referred very often. I referred to, and Stephanie referred to yesterday. It is Association Syndicale. Then it is the judgment I referred to yesterday, and Stephanie as well. That consent the request for preliminary ruling from High Court Ireland. And it concerned the European arrest warrant, and it concerned Poland. I mean, it was in fact Polish case. And then the judgment called Achmea. In the most important judgment, Association Syndicale, the court recalled that according to Article 2 of the Treaty on the European Union is founded on values such as the rule of law, which are common to the member states in a society in which inter-area justice prevails. And then adding, the European Union is a union based on the rule of law, in which individual parties have the right to challenge before the courts the legality of any decision or other national measures relating to the application to them of an European Union Act. And then Article 19, which we just elaborated yesterday, which gives concrete expression to the value of the rule of law. It is concrete expression to the value of the rule of law stated in Article 2, and trusts the responsibility for ensuring judicial review in the European Union legal order, not only to the Court of Justice, but also to national courts and tribunals. This is what we said yesterday. I mean, national courts and tribunals are functionally European courts, European tribunals, European judges. National judges are at the same time European judges, because national judges apply and interpret European Union law. That's why national courts and tribunals, in collaboration with the Court of Justice, fulfill a duty entrusted to them jointly of ensuring that in the interpretation and application of the treaties, the law is observed. Court of Justice as well referred here to sincere cooperation or judicial cooperation between courts. It is important. It is that's why. Rule of law is important because national courts, they must cooperate with European Court of Justice, and they must refer. They do not have to be afraid of referring questions to the European Court of Justice. That's why this sincere cooperation, this judicial cooperation, is very important, and it is an element. It is an element as well of the effective judicial protection, and we can say in broader terms of the rule of law. Referring to the effective judicial protection, the court said, since national courts can decide on issues relating to the application and interpretation of the European Union law, hence the member states' consent must ensure that that court meets the requirements essential to effective judicial protection in accordance with the seventh subparagraph of Article 19. I don't know if I do have to. Okay, and then another element. It is fair trial, where the Court of Justice said it must be pointed out that the requirement of judicial independence as an element of the rule of law forms part of the essence of fundamental right to a fair trial, a right which is of cardinal importance as a guarantee that all the rights which individuals derived from the European Union law will be protected, and that the values common to the member states set out in Article 2, in particular to the rule of law, will be safeguarded. I mean, this right to a fair trial. And then, in accordance with Article 19, which gives concrete expression to the value of the rule of law, affirmed in Article 2, it is for the national courts and tribunals and the Court of Justice to ensure the full application of European Union law in all member states, and the judicial protection of the rights and of individuals under the law. And then, what does I referred to? Court of Justice referred to the sincere cooperation and mutual trust as an element of the broadened understanding of the rule of law. Okay, then maybe I will read it. European law is thus based on the fundamental premise that each member state shares with all other member states and recognizes that they share with it and set of common values on which the European Union is founded, as stated in Article 2. That premise implies and justifies the existence of mutual trust between courts, between national and European court, between the member states, that those values will be recognized and therefore that the law of the European Union that implements them will be respected. It is precisely in that context that the member states are obliged by reason inter alia of the principle of citizen cooperation set out in Article 4 to ensure in their respective territories the application of and respect for the EU law, and to take those purposes any appropriate measure, whether general or particular, to ensure fulfillment of that obligations arising out of the treaties or resulting from the acts of the institutions of the European Union. And as far as operation of this, what we understand under rule of law goes, since this provision is enshrined in Article 2 of the Treaty on the European Union, then we have to see how Article 2 of the Treaty on the European Union is operationalized, and we can do it when we refer to the judgment of 2018 Association Syndicale. And this judgment, in this judgment, which was issued in 2018, is very often seen in many publications as having such an importance that it is of a constitutional nature, because it operationalizes Article 2 by interpreting it in conjunction with other treaty provisions. And in this way, Article 2 becomes an effective tool to protect rights of individuals, which can be effectively used in proceedings before national courts. The rule of law included in this provision, which so far has been protected by political ineffective mechanism provided by in Article 7. That is, I just referred yesterday to Article 7, that we have, as far as rule of law is concerned, we have this political mechanism, we have this legal mechanism, and we have economic mechanism, which has lived as long as the economic mechanism. But as far as political mechanism is concerned, it was Article 7 and this pre-7 article communication of the European Commission from 2014. But this political mechanism, it is ineffective and still the procedure is there is no decision of the Council of Ministers, or the Council of Ministers should have taken the decision, did not taken, but it is a kind of dialogue between Council of Ministers or Council of the European Union and the state involved, in this case the European Union. But because this mechanism is ineffective, then we just resort to this judicial mechanism. And provided for in Article 7 gains a new powerful nuclear weapon, which is decentralized, for it can be used by any national judge, functionally a European judge, while adjudicating in an individual case. It means that because in previous lecture, Andreas, you just referred to Article 7 as a nuclear weapon. Yes, very often, yes, Article 7 is seen as a nuclear weapon, but now, as well, it is Article 2. It is Article 2 in conjunction with Article 19, Treaty of the European Union, rather than Article 7, because Article 7 as a political, being rather political than judicial, is occurred to be ineffective. And the effective, it is Article 2 in conjunction with Article 19 and in conjunction with Article 4. The facts were as follows. In 2014, the Portuguese legislature introduced a temporary reduction in the remuneration of employees working for the Portuguese public administration, including judges. The issue is that the reduction in remuneration or curtailment of remuneration, it was not only for the judges. It touched upon other employees. Other employees from the public sector. These were prosecutors, but as well civil servants. I think as well the president and the prime minister were as well touched by this law. The Association Syndicale, acting on behalf of the members of the Court of Auditors, decided to challenge the salary reduction measures on the ground that they would infringe the principle of judicial independence enshrined not only in the Portuguese constitution but also in European Union law, namely in Article 19 Treaty of the European Union, which says that the member state shall provide remedies sufficient to ensure effective legal protection in the fields covered by European Union law. And in Article 47, right to an effective remedy and to a fair trial. Hence, the question was referred by the Portuguese Supreme Administrative Court to the Court of Justice of the European Union for a preliminary ruling. But before concluding that the salary reduction measures at issue in the main proceedings cannot be considered to impair the independence of the members of the tribunal, the Court of Justice refers to a number of criteria that should be followed by national courts when reviewing measures that may infringe judicial independence. I mean, the issue was that, in fact, the answer of the Court of Justice was that this national measure, the curtailment of wages was because it was not targeted only judges, and because it was of a temporary nature, it was justified. And this what was done was not breaching European law. It was not against the independence of judges and judiciary. But two elements are innovative here. The adoption of Article 19 as an independent legal basis, what we just talked about yesterday, I referred, and Stephanie as well, for settling the issue by adopting a broad interpretation of the court by the court. The court has extended the scope of legal protection. However, Article 19 requires European Union connecting element in the fields covered by the European Union law. In order to apply Article 19, the court had to find such a link. And here comes the second element. The court applied a systemic interpretation by referring to the European Union legal system and to the European Union itself. It also referred to the catalogue of values which are enshrined in Article 2 of the Treaty on the European Union and the rule of law contained therein. It found that the principle of effective judicial protection of the rights that individuals derive from the European Union law, to which Article 19 refers, constitutes a general principles of law, hence derived from the common constitutional traditions of the member states, as expressed in the Article 6 and 13 of the European Convention of Human Rights. It would apply even in the absence of a positive regulation in the primary law, and in the judgment we can read that the principle of the effective judicial protection of individuals' rights under European Union law referred to in the second subparagraph of Article 19 is a general principle of European Union law stemming from the constitutional traditions common to the member states, which has been enshrined in Article 6 and 13 of the European Convention of Human Rights, signed in Rome in 1950, and which is now reaffirmed in Article 47 of the Charter. And to justify the judgment, the court applied a joint interpretation of three provisions. And one provision, it was Article 19, and it constituted here an independent legal basis, a ground for setting the case, in conjunction with auxiliary application of Article 2, the rule of law as European Union value, and then Article 4, principle of sincere cooperation, judicial cooperation, mutual trust. The combined application of these three provisions allowed for a convincing justification of the court's decision. And the court begins with reference first to Article 2, then recalls that the European Union is founded on the values such as the rule of law, which are common to the member states in a society in which justice prevails. And in Obiter Dicta we can read, according to Article 2, the European Union is founded on values such as the rule of law, which are common to the member states in a society in which inter alia justice prevails. In that regard, it should be noted that mutual trust between the member states, and in particular their courts and tribunals, is based on the fundamental premises that member states share a set of common values on which the European Union is founded, as stated in Article 2. And since the European Union is a union based on the rule of law, in which individual parties have the right to challenge before the courts the legality of any decision or other national measures relating to the application of an European Union Act, Article 19, Treaty on the European Union, which gives concrete expression to the value of the European Union law, stated in Article 2, entrusts the responsibility for ensuring judicial review in the European Union legal order, not only to the Court of Justice, but also to national courts and tribunals. Then the Court referred as well to the fulfillment of a duty entrusted jointly to ensuring that the interpretation and application of the treaties the law is observed, and as well as referred to the sincere cooperation, and effective judicial protection. And then said that the very existence of effective judicial review designed to ensure compliance with EU law is of the essence of the rule of law. It is something what just appeared in other cases which were decided before this judgment of 2018. Then, okay, do we have time? Okay, it is 16. Oh, it is 15:06. Okay. And it also said that to the extent that the Court of Auditors may rule as a court or tribunal on questions concerning the application or interpretation of European Union law, the member state concerned must ensure that that court meets the requirements essential to effective judicial protection in accordance with the second subparagraph of Article 19. Moreover, some statements made by the Court of Justice can be seen as a guidance for the member states in order for that protection to be ensured. Maintaining such a court or tribunal's independence is essential. Court here referred to the independence of the judiciary. The guarantee of independence, which is inherent in the task of adjudication, is required not only at EU level as regards the judges of the Union and the Advocate Generals of the Court of Justice, as provided for in Article 19, but also at the level of the member states as regards national courts. And the independence of national courts and tribunals is in particular essential to the proper working of the judicial cooperation system embodied in the preliminary ruling mechanism under Article 267, Treaty on the Functioning of the European Union, in that mechanism may be activated only by a body responsible for applying EU law, which satisfies inter alia that criterion of independence. The concept of independence presupposes, in particular, that the body concerned exercises its judicial functions wholly autonomously, without being subject to any hierarchical constraint or subordinated to any other body, and without taking orders or instructions from any source whatsoever. And that it is thus protected against external interventions or pressure liable to impair the independent judgment of its members and to influence their decisions. And here, the two remarks which appear or just pop up. After the Treaty of Lisbon, which confirmed the principle of conferral, it seemed that the Court of Justice's judicial activism would become a history. The opportunity was seen in the Charter, but as we see, the application of the Charter is limited because of Article 51 of the Charter, which limits the application of the Charter to the provisions of either primary or secondary law. It means that the provisions of the Charter can be applied in case or when member states implement a European Union law. When they do not, then the provisions of the Charter do not apply. In the judgment of 2018 Association Syndicale case, the court discovered, we can see here, we can say that these are new possibilities for the development of its judicial activity and started anew. This is what we call judicial activity. An interpretation of Article 2 in conjunction with Article 4 and with Article 19 was used to justify the protection of judicial independence. Article 2, Treaty of the European Union, Article 4, Treaty of the European Union, and Article 19. We can say that in the future, this precedent may be used in such a way that the value enshrined in the catalogue of Article 2 of the European Treaty will be linked to another treaty provision which until now has not been considered as an independent legal basis, thus opening up new opportunities for the court to adjudicate. This precedent, which was established in a way, because it is a precedent, which was established by this judgment of 2018, can be, in German it is Vorbild, can be a model, a scheme, for other precedents. Article 2 in connection, not necessarily with Article 19, but with different article, can set another precedent. The value taken out of Article 2 in connection with one of the treaty provisions, and then setting another precedence. And it is also said, just reading, some books, some articles on the, on the issue, what the rule of law is. It was sometimes referred that the judgment, association syndicale, is such a novelty, it is such a precedent, it is such a it is of a constitutional nature, it is such a revolutionary judgment, then that it can be seen in terms of federalization of the European Union. Whether it can be seen in terms of federalization, I would say that in a way, yes, because it opens new possibilities for the European Union institutions, for the Court of Justice, to govern on the day-to-day basis, the structure which we call the European Union. The governing of the structure, the holding into account of the not only member states but also institutions, sub-state entities and other entities, as well private entities, will be easier. And in this way, we can see it as an element of a federalization of the European Union. Federalization for us, it is something what is close to a centralization. But here we have because it can be decided by the Court of Justice of the European Union. Yes, it is a centralized element. But we saw the decentralized element under Article 263, because it was decided by the Court of Justice. It is a centralized element, but at the same time we had here this decentralized element, because the case could be referred to the Court of Justice of the European Union via Article 263. It was this combination of centralized and decentralized elements. But federalization for us, it is rather centralization than a decentralization as far as the European Union is concerned, because there are different opposite trends as far as federalization as such, the process of federalization is concerned. The Court of Justice of the European Union created an instrument for the protection of judicial independence, which is considered a general principle of European Union law. National judges were given an opportunity to challenge politically motivated wage cuts. In this way, an institutional barrier was created to protect independence of judges from attempts to subordinate them politically to the executive or to the legislature. The court stated that the protection of judicial independence is not an exclusive domain of a national regulation. It is not, because the organization of judicial system, it is a competence of member states. It is a national competence, but it has its limits. And states cannot, without limits, regulate the status of judges and the judiciary. They are constrained by the principle of judicial independence, which, as a general principle of law, is the constitutional value of the European Union. Principle of judicial independence, being a general principle of law, is of a constitutional value, forming a part of rule of law. But what I wanted to add, that in this case, it is not so clear whether what the issue was about, because because the curtailment of the remuneration of the wages of judges, it was done because of, we can say, of the implementation of the European Union law. It wasn't a direct, a strict implementation of the European Union law, but it was a requirement from the European Union institutions to decrease the amount of national debt. And in order for government to do it, government had to undertake certain measures. And one of the measures was to curtail the wages of civil servants, judges, prosecutors, and other civil servants. That's why it was an issue here. European law was involved. It means that Portuguese government in a breached European law in the way of curtailing independence of judges, but at the same time doing something what was required by European institutions. It means that here, in fact, European element, it means this requirement, which was indispensable. Portuguese government had to do it, had to undertake certain measures, and it wasn't so easy. I mean, to impose new taxes, to decrease the debt of the budget. Then the easiest way was to curtail the wages. Then it was one issue. It was an economic requirement, and it was, I mean, it is strange that the requirement came not from national government as such, but the requirement came from the European Union, and then it was temporal, and it touched not only judges. That's why it could be justified. I mean, this breach of European Union law in the meaning of breaching independence of national judges functionally being European judges was at the very end justified. And other issues surrounding the rule of law, European identity versus national identity. I mean, the issue is that that rule of law falls under this what we call national identity. National identity very often is seen as constitutional identity. Rule of law forms a part of this constitutional core. This constitutional core, these are the provisions of each constitution which are immune from the European institutions dealings, acting. They are immune from judging by the European judges on these issues. They are immune from any intervention from outside entities, outside bodies, external institutions to deal, to act, to regulate these issues, to touch upon these issues, because these are the most important elements, the fundamentals on which they are enshrined in the Constitution, but they are fundamentals for the functioning of the whole structure of the whole system, of the whole country. And the rule of law is one of these elements. It's very you can say that it relates directly to the sovereignty of the country. And in the history, we had this a kind of dialogue, conversation. Sometimes it was a competition. On the one hand, we had national courts, either Supreme Courts or constitutional courts, which defended this national identity, constitutional identity, this constitutional core, these basic values. And on the other hand, we had European Court of Justice that was not satisfied, that wanted to impose one standard, and sometimes while imposing one standard infringed or touched upon this constitutional code, these provisions of national constitutions which are supposed to be immune from the external and foreign alien interventions. And it is an issue as well in Polish institutions. They fall under Chapter 1 and Chapter 2 of the Constitution, which is supposed to form this national constitutional identity. That's why it should be immune from European judges judging on this issue, judging on the rule of law. But on the other hand, the Constitutional Tribunal, in one of its judgments, said that it recognized the existence of common axiological core, and this common axiological core, it finds itself in the Constitution. It is Polish Constitution, European Charter on Human Rights, and European Convention on Human Rights. And in the European Charter on Human Rights, we saw that there is this principle which we call rule of law. It means that in one of its judgments recognized the rule of law as constituting a common axiological core, but on the other hand, does not allow European institutions judge upon what is called the rule of law. Yeah, it is difficult problem because it touches upon national sovereignty, and it is, on the one hand, it is for the Constitutional Court. It is for the Constitutional Court to defend constitutional provisions, but it is for the European Court of Justice to defend its principles. And but this what constitutional courts do. It reminds me what Court of Justice did in the Kabat judgment. Did the same what constitutional courts do. Defended European values against external interference from the United Nations. And during the crisis related to the compliance with the rule of law in the European Union, there were voices that the national rule of law differs from the European Union rule of law. The Polish government argued that the reform of judiciary is an internal matter and the European Union has no competence to deal with the issue. This aspect of the rule of law would therefore be excluded from the scope of European Union rule of law and would fall under the concept of national identity. It was the sense that on the one hand, recognized common axiological code, and under this common axiological code, there is rule of law, but on the other hand, says that rule of law as such falls under national identity, which is translated into constitutional identity. But because national identity it is a very vague concept, but it can be translated and operationalized as constitutional identity. The Constitution of the Republic of Poland allows for the transfer of powers to state organs to international organizations in some matters. Limitations in the conferral of competences are determined by the basic principles which are set out in the Constitution, as I said in the first and in the second chapter, where we find the principle of the rule of law. And it is stated that in the Constitution, democratic state ruled by law. I just refer here. It just remind me when Andreas, you just told about you wanted to marry rule of law with democracy. Yes, it was democracy and the rule of law, and we have democratic state ruled by law. It's written in the Constitution. Moreover, the Polish Constitutional Tribunal recognized Article 90 of the Constitution as normative anchor of sovereignty, defining the limits of delegating powers to international organizations. It is in Article 90. We have two articles, and Article 90 allows the delegation of powers, the conferral of powers, the delegation of powers to other entities, to international organizations. And these boundaries are determined by the constitutional identities, which includes, among others, the rule of law. Then we can say that the state may transfer competences to the supranational level, leading may not transfer competences to the supranational level, leading to the questioning or limiting the rule of law, but may transfer competences leading to the strengthening of the principle. Competences enabling the control of compliance with the rule of law in a member state and thus strengthening the rule of law at the national level. Now, at present, at this stage, at actual stage of integration, it is not possible to speak about European rule of law. We do not have, and it is the problem that we do not have European rule of law. We do not have something what we can call a European rule of law. We have European rule of law, but in fact we derive it from member states, and the understanding of the rule of law may differ, and on the European Union level, and as well understanding of the national level, what national rule of law means and what European rule of law means. And we can say that in addition to 27 legal orders and thus different approaches to rule of law, there is an independent and inclusive, but though not consuming, European rule of law. It is for me, it is a concept that it is more a complementary to national concepts rather than autonomous, because it is derived from national constitution, and it takes as well the meaning from national constitutions. And then we have the treaty-based and non-treaty-based integration, and the advancement of non-treaty-based integration. I mean here the integration that can proceed on the provisions of the Charter of Fundamental Rights, and thus the enforcement of the rule of law is limited by Article 51, because we cannot proceed, we cannot deepen, we cannot proceed with the integration based on Article 51. Based on the provisions of the Charter, when we do not implement at the same time a European Union law. Which limits its political application, as the member states are bound by the Charter only to the extent that they implement European Union law. It means that this non-treaty-based integration based on the Charter of Fundamental Rights is a part of European Union law, of course, but it is limited by Article 51. And then we have as well different understanding of the rule of law, as the standards related to the rule of law are created both at the level of national and supranational constitutions. Some aspects of the rule of law can be understood differently in the legal system of the member states, and this risks undermining the effectiveness and uniform application of the European Union or European Community law. Protection of, and it is just something what I just not invented, but the protection of national sovereignty is passé, because we do not tend to speak anymore about national sovereignty, about the protection of national sovereignty, but protection of national identity, but emphasizing constitutional distinctiveness is our mode. It is more often than not member states speaking about defending its competences. They tend to refer to national identity, constitutional identity, rather than sovereignty. And the rule of law is one of the elements that falls under national identity, at the same time national sovereignty. And then the issue of multi-level governance. What does I refer to? This multi-level structure, this European structure, which is multi-level structure, and being multi-level structure, it is a federal structure. It wouldn't work if there had to be a legal instrument, or if legal instruments didn't work. If law does not work, then the European Union is doomed to fail, because it is the only instrument that by which European Union can hold member states into account. And rule of law is one of such instruments. Then we have another concept. It was not now, but 20 years ago. It was very popular. Constitutional pluralism. I mean, in the first, it was after 2001, especially after 2001, constitutional pluralism, which presupposes that member states have the right to be guided by their own values. This constitutional pluralism goes in a line with the interests of the member states. Constitutional pluralism. We have many constitutions. We have many values. We have many interests. We have many different understandings what the constitution is. And this right is guaranteed in the treaties. It is Article 2, which requires the European Union to respect national identities. It means that European institutions must respect national identities, translating into respect of national constitutions, inherent in their fundamental structures, political and constitutional, inclusive of regional and local self-government. However, this pluralism but not only has, but this pluralism must have certain limits. Because otherwise, as I said, this constitution, the whole structure, will be doomed to failure. And these limits are defined by the common values which are enshrined in Article 2. And it is so-called constitutional consensus on understanding common values through constructive dialogue between the Court of Justice of the European Union and national courts. However, with regard to the independence of courts and judges, such a consensus already exists, and these values are recognized as general principles of law. It means that, okay, on the one hand, we refer to constitutional pluralism, and it is in line with member states' interests. I mean, the recognition of constitutional structures, of constitutional and political structures, of political systems. We can say recognition and respect for national constitutions, but on the other hand, there must be a limit, and the limit is set in Article 2 on the Treaty of the European Union, and these are the values which must be upheld by each and every one. I mean, constitutions are important, they must be respected, they have to be respected, but there is a limit, and this limit is set in Article 2 on the Treaty of the European Union, and one of the values is rule of law. Then why is the rule of law such a silent issue? Because the European Union is not a state, it is an international organization, it has not coercive power. It is first and foremost a legal entity, a community of law, and only the adherence to legal rules and principles, including, among others, the rule of law, by all states, high contracting parties, makes possible the European Union further existence and development. This is important that every state obeys the law, rules and principles, for there is no European Union without the law, and it is crucial. Without the law, without the well-functioning legal system, I mean, there is no European Union, but because it is the only instrument that European Union has at its disposal. Okay, one can say there are others, because the European Union has its finances, but in fact they are not finances of the European Union. I mean, they're decided by the member states rather than by European Union institutions. But as far as EU instruments are concerned, it is law. Then without law, there is no European Union. There is no construction. This whole construction, without well-working law, the whole construction is doomed to failure. Even if the rule of law were not included in the treaty, it would apply as a general principle of European Union law, derived from the constitutional traditions of the member states. Under the present treaty, it is Article 2, should be considered as a sanctioned norm, and to Article 7 as sanctioning norm. However, Article 7 is so imperfect that attempts have been made to extend the extra treaty mechanisms. When we have these legal provisions, on the one hand there is a sanctioned norm and sanctioning norm, but here, yes, we have Article 2, but then we have Article 7. With Article 7, this political instrument, it is very difficult to sanction the the obligations which are imposed under Article 2. That's why extra treaty mechanisms for the protection of the rule of law in the member states have been invented, have been developed, and one of such instruments is the EU framework, the communication of the European Commission of 2014, what I referred to yesterday. And another instrument, it is dialogue, which is conducted by the Council of Ministers or Council of the European Union, the institution that we call now, with the member states. But this dialogue proceeds, and no decision is taken as for now. And the judicial mechanism is by far the most effective. We saw it yesterday, that this judicial mechanism via Article 258, not via Article 259, because we have the same similar provision in 259, but it is very unlikely that the state will launch a procedure, an infringement procedure against a state, just thinking that maybe in the future it will be vice versa. Then it is very unlikely. Then we have this Article 258, the infringement procedure, and then we have preliminary ruling 267. Okay, we have 278 and 279, but it is an interim measure imposed by the European Court of Justice on the request of the made by the European Commission. And economic measures also play a role. They do play a role, but they since now they are not implemented. Okay, there is a resolution which was not resolution, not resolution, but there is a regulation. There is a regulation, but this regulation was taken by Poland to the European Court of Justice. It was just because we do not agree with that European funds, this new funds, new generation, will be connected with the compliance with the rule of law, because there is this conditionality. If a state does not comply with the rule of law, then there will be a curtailment in the as far as European funds are concerned. Then we do not agree, and Poland took this case to the European Court of Justice. And economic measures also play a role, but if they are effective, you will just see. But here is European institutions. They are. Economic measures, finances are important, because European institutions or European structure, European Union does not want to finance governments. They do not governments which do not comply with the rule of law, with the governments which do not comply with the basic values, and it is an issue. That okay, they did, because giving money or just not sending money but giving money means in a way supporting the economy, and in this way indirectly the party that does not obey does not comply with the rule of law, and it is an issue. It is an issue. Another one that is at stake when we speak about rule of law, not only legal but as well economic, and political. On the other hand, political mechanism does not work, for its effectiveness depends on the goodwill and cooperation of the member states, without which it turns out to be ineffective. Yes, it doesn't work, because as we saw in Article 7. Article 7, it is two-stage procedure, and stage 1, it is a Council of the European Union that decides by 4/5. And it is not so easy, to get this vote. Okay, it is not unanimity, but still, as we see, Council hasn't taken a decision. And if some measures are going to be imposed, these measures will be imposed, but when there will be decision taken, not on Article 7.1, but on Article 7.2. And here we have unanimity, and we have here not Council of the European Union, but we have here European Council taking the decision. Okay, European Parliament has there is requirement of the agreement of the European Parliament, and then after there is decided that indeed there is a systemic breach of the rule of law, then other measures can be decided by the Council of the European Union. It is majority vote, but first it is unanimity in the Council, in the European Council. Then it is very political. It is very intergovernmental. On the one hand, okay, it is political, but it is. I mean, here sovereignty, national sovereignty is as well at stake, and that's why it is now easy to proceed under this procedure under Article 7. It requires a lot of goodwill on the part of the member states, and as we saw, I mean, today and yesterday, it is not only the case of Poland, it is as well the case of other states. Then it will be not so easy, I mean, to get 4/5, and not to speak about unanimity in the Council, in the European Council. In the European Union, the rule of law has been elevated to the rank of values. It means leading axiological category underlying the existence of the Union, an element. We can say that is an element of the European constitutional identity. It means that when we are talking about the rule of law, we are talking about one of the basic, of the most important, of the fundamental principles that is enshrined in this, what we call European Constitution. European constitutional identity forms part of European constitutional identity in parallel as it is in the national context. Rule of law forms part of national identity. Here, rule of law, European rule of law forms part of this, what we can call European constitutional identity. Okay, I speak about the concepts that which are not always recognized, which are very often contested, which are very often challenged, which are maybe sometimes not politically correct, speaking about constitutional identity, European constitutional identity, European constitution, European federalism, but I mean, the whole structure, I mean, develops, I mean, a very deepening of the integration processes in this direction, and rule of law is one of the important instruments that helps proceed with the deepening of European integration. I mean, making the structure more perfect, workable, that can be well governed on the day-to-day basis, and they can serve not only, the most important, they can serve not only the member states, but first of all, that can serve us citizens, European citizens. Okay, thank you very much. Sorry, I spoke. I think I spoke too quick, but.
No, that's okay. I was wondering if I could ask a clarification about something, and then I also have fun. So my clarification is about something you said on page 23. This has to do with a recognition by the Polish Constitutional Tribunal that there is a common axiological core of the Constitution, the Untitled Chapter, and the Convention on Human Rights.
I do not have here pages, but
it's on page 23.
Yes, but I do not have here pages. Can you repeat it?
Yes. So
this common axiological. Yes.
Something that the Polish Constitutional Tribunal recognized. Yeah.
Yes, but on the other hand, said that it falls under national identity.
All right. So my question is. So the Polish Constitutional Tribunal did not recognize that the rule of law is part of that common axiological core, or is it that they thought some elements of the rule of law are part of the core?
I would say that differently. Speaking about common axiological core, referred to the Polish Constitution, to the European Charter of Fundamental Rights, and European Convention of Human Rights, but did not indicate specifically. You know, it was only in general terms, maybe you wasn't even aware of. Okay, there are people that know what they are talking about, but it was in general terms, yes. But now when I look for arguments, just then. And it was said in general terms, but for me, okay, but under the Charter of Fundamental Rights, there is rule of law. Then if the Polish Constitutional Court referred to it, then should have been aware of it, and then I can infer from this that rule of law is part of this constitutional axiological core that is recognized by the Constitutional Tribunal. But on the other hand, yes, we saw that that it does not have to be the case. But with courts, it is once they judge, they decide in this way, and then after several years, the judgment is quite different. But okay, it shouldn't be so. But it was very general reference. Yes, that's why it was not specific reference to the rule of law.
But so the thing that I'm trying to understand is, does the Polish Constitutional Tribunal think of the rule of law as being something of rights that needs to be protected? Does it think that some elements of the rule of law are rightly to be protected? Because I understand that the point in this case is that the EU should stay away from what we're doing here in terms of destruction of the judiciary, because that's part of our sovereignty. We're allowed to do that. So the EU cannot interfere. That's kind of what the court is saying in this case, isn't it? And so my question is the court recognizing some aspects of the rule of law over others, or is it a case of just pushing the populist agenda wherever it leads us?
No, it was even it is here. The stance of the Polish Constitutional Court is so that in general, rule of law falls under national identity, constitutional identity, translated into national identity, then it is immune from the European institutions. But there are some elements that they can be regulated at international level, but when they are regulated in this positive way, that they help strengthen the national rule of law. It means that they do not contradict. If it is in line with our national rule of law, then that is okay. But if there is a contradiction, if there is a challenge of our rule of law, then they will not agree.
So, but what does national rule of law entail? Does it entail judicial independence, for instance?
Yes, it is. But first of all, it is the organization of judiciary. I mean, it is organization how judicial system in Poland is organized. I mean, it is the competences of Minister of Justice, the competences of the Prosecutor General. I mean, the tenure office of judges, the composition of some institutions as disciplinary chamber, as national chamber for judiciary. I mean, it is the organization understood very in broader terms. The organization of judiciary, it falls under rule of law, and it should be immune from the European institution, from the intervention of the European institution. And here we see, because if it comes something that helps strengthen our rule of law, that's okay. But if it contradicts, and now there is a clash between Polish positions, Polish argumentation, Polish dealings, and between the stance of the European institutions of the European Court of Justice. Polish Constitutional Court does not agree with this situation when it comes to challenge, and it came because we reformed our judicial system, and in fact many elements of the system were challenged by the European Court of Justice. I mean, many elements. But if it came, for example, that only one element was changed, I don't think there would be there would be an intervention on the part of the European Court of Justice, because it was said not only by the Court of Justice but as well by the Advocate General that individual elements, they do not play such a great role, but taken together it is an issue, only taken together. Then the organization of justice, understood very broadly, it is something what falls under the rule of law, and here as well independence of judges comes into play, because it is okay. It is not an emulation, but the tenure. The tenure. Then disciplinary proceedings. That is an issue. Now it is an issue. The institutions, the composition of the institutions that can take disciplinary measures against judges. It is another issue. Then what we just talked about, the possibility of reopening the cases, reopening the cases and dating 20 years back. It can go 20 years back, and it is not only because of the case. It is not only the case, but as well the judge. The judge decided upon the case. Then it falls under disciplinary offences, disciplinary proceedings against judges. Then organization of judiciary, broadly understood, falls under the rule of law. But in fact, it is everything. Okay, rule of law is also separation of powers. Yes, it is also legal certainty. But legal certainty, it falls under, it is judiciary, because the extraordinary procedure, it falls here. Legal certainty is at stake. Okay. Yeah.
I have here a quote. I'm reading again. I'm following what she's doing, and I'm reading again Advocate General Bobek's opinion in the case that is pending for this in the Prokuratura case.
Yes.
And he says basically, let's not hide it. The true nature of paragraph 2 of Article 19, paragraph 1, the illiquidity, is simply an extraordinary remedy for extraordinary cases. Therefore, the access threshold in terms of admissibility is and ought to remain low, while the substantive threshold for its breach is relatively high. And then he continues in other paragraphs, and he says, so the role of the national courts reviewing measures allegedly affecting the judicial independence of national courts cannot but be limited to pathological situations. This is, it explains it. It's not going to look at all the organization and the composition
that's true.
of the court, but the problem is, what is the pathology? Where is the protocol to determine that sort of pathology?
But I think that points to exactly what Danuta's presentation has been about the absence of European rule of law idea or value or principle, however you want to call it, that kind of lays out those provisions and therefore enables someone like a prosecutor or a judge to pinpoint cases where those pathologies actually take place.
Yeah, where's the protocol? Like in medicine, we're talking about pathology, we need a protocol.
Yeah, we need a protocol. Yes, we need European rule of law. But if we have European rule of law, do we have European Constitution, and do we have European state? Yeah, these are the concepts that they are derived from national settings, and when they go to international settings or supranational settings, then where are the question is: are member states afraid of European rule of law? Or are they afraid of what will bring then, European rule of law? It will develop. The same was with the principle of supremacy. It wasn't enshrined in the treaties. It was derived from the constitutional traditions of the member states and general principles of law. Okay, it is the principle of supremacy, but no one speaks about principle of supremacy. Hardly anyone. If we speak, then we speak rather about the principle of primacy, and there is a difference between primacy and supremacy. But it is in fact the principle of supremacy, and principle of supremacy. It is nothing more, nothing less. But it is Bundesrecht, Bricht, Landesrecht. It is the main principle in federal settings. Okay, but otherwise, without these principles, this structure, this supranational structure wouldn't work. Okay, it can be. We can just go back to international organization. I think it was yesterday. I didn't intervene yesterday. I think maybe it was your comment. What to do? Yes, it was about Brexit. What to do? Whether to let member states more competences. And get rid of the European Commission. But if we get rid of the European Commission, then they will set another institution. Okay, to their liking. To their interests. But okay, we can do it. Okay, we can do it. We can proceed. We can go backward. Yes, we did it in Lisbon, because under Lisbon it is possible for competences which are not anymore executed on the European level. They are taken back to member states. It is possible. If they are not applied anymore, if they are not needed at European level, it is possible that they go back to the member states. But if we now go back with this integration, it means we go to the intergovernmental classical organization. What about us? What about us citizens? This supranational structure, from my point of view, as an individual, as a citizen, I see positive outcomes, because it is in my it works. It should work in general interest of the member states, but as well subjects of European Union are not only member states but also citizens. And this strong supranational structure working under federal principles is a structure that is closer to an individual, that makes more for an individual. And I wouldn't like to be under intergovernmental organization. Then it is up to the member state, up to the state, up to my state, what my rights are. Now, it is not only it is up to my state, but it is as well, I have direct rights and obligations deriving from the European Union. I do not need in many cases my state to give me these rights, because I can derive direct rights from the European law, from the European provisions. That's from the point of view of an individual. I think that the stronger European Union, the better. Okay, from the point of view of the member states, then it can be quite the opposite. Quite the opposite, because the stronger the member states, then the weaker the organization. Then we are going back to intergovernmental organization. Yes, but European Union. But we shouldn't be afraid of European Union. It is an It is an international organization. It is based on the treaties. It is not a state. But it works according to the principles which are the best, because which allows them to fulfill its tasks. Yeah, because there are tasks, aims. What is written in the treaties. Then, we shouldn't be afraid of the European Union, and even with the rule of law, we shouldn't be afraid of European superstructure, European state. I am not, and I wouldn't say that it would develop in this direction. Okay, at least not now. What will be in the future, we'll see. But it is structure which is complementary to the member states, and it has its own aims, tasks, duties, But the structure is why we need the European Union as well. We say, okay, European Union works according to the competences that were conferred by the member states. Okay, but the European Union has as well its own competences. European citizenship. Which state gave these competences? It is the competences originally the European competence, because no state has such a competence to impose European citizenship. European Monetary Union, Euro, it is not the competence of the member states. Okay, member states conferred some of the competence in the monetary domain, but Euro is not the competence that member states could confer it because they did not have. Then we can say that European Union develops in a way its own competences.
Sure.
Yeah,
that's the whole point.
Yeah, that is the whole point. That the competences which were not originally member states' competences. Now, take citizenship.
Yeah.
Sorry?
No, it's just
Yeah, but okay,
Highly problem.
yeah.
Okay.
Okay, thank you very
Thank
much.
you so much.
Thank you very much. Sorry that I was a little quick, but I wanted to be in time.
We needed time to chat. So
Yeah, and okay, thank you very much.
Anyone online who would like